This is a Miner's Minute, a conversation with James Buchal, a mining attorney.
In particular is the Backlund case. Could you explain what was going on there and how the stupidity of the Forest Service is sort of magnified in this situation?
Well, this is actually interesting. The new innovation out of the Obama administration is to attack the miners through means that do not allow the miners due process of law. And by this I mean for many years, when someone was working on a mining claim under a plan of operations, and there's a dispute about the plan, the Forest Service would have to go to court and essentially win an injunction against the miner to stop them from doing something. The Forest Service has two new ideas on this, and one is to essentially charge the miners criminally for unauthorized occupation of their claim. And that gives rise to the case that I have pending in the Ninth Circuit right now. A miner named Michael Backlund was living on his claim in Oregon, and he had been restricted over the years to doing very little under a plan of operations. And ultimately they told him, okay, well now you're not doing enough because we won't let you do anything, so now your occupancy of the claim is no longer justified. And he says, screw that. The mining law says that the public lands are free and open for occupation. And so the ranger was just wrong when the ranger said it was illegal for me to occupy my claim because I'm actively mining. And there's no dispute that he was actively mining. So they cited him criminally for the misdemeanor of essentially occupying the land without an approved plan. And we went to criminal court. And in criminal court, the district judge said essentially, well, I'm not going to let you litigate whether the ranger was right or wrong. If the ranger told you you needed an approved plan to occupy the land and you didn't listen to her, you are now a criminal. So that case is up in the Ninth Circuit Court of Appeals. We've pointed out that there's something very wrong with having the ranger's word be law, which cannot be reviewed at all, as well as something very wrong with the idea that Congress ever intended the Forest Service to criminalize mere occupation. And it's a great test case because there's no claim of any environmental harm or damage whatsoever. The only argument is you're occupying, you don't have permission, you're a criminal. That case is pending in the Ninth Circuit, could be decided any day now. The other clever trick that they've decided, and Oregon is sort of the hotbed of this, they have the test case on the criminal side. The test case on the civil side is they came in and they said, okay, we're having a fight about the plan. Now we're going to send you a notice that you have to remove all your property in 90 days or we'll seize it. And they used a statute or a regulation intended for like lost knapsacks and cars that are left behind. And the miner said, you're crazy. You know, this is not personal property like a knapsack. You can't take my buildings. But they said, oh, yes, we can. And they burned them down. And so we are now suing the Forest Service for the destruction of the buildings. We obtained an order from the court saying that she thought the government was liable. That case may settle. We'll see what happens with that.